universities, along with the support of our government bodies, has been organizing this symposium to offer a platform to deliberate and discuss not only the recent most developments in the field of transnational commercial laws, but also to discuss the way forward in the field in view of the industry demands and how the states across the world are undertaking policy making. It will be interesting today to gain a perspective, not just domestic, but also an international perspective on the existing transnational commercial laws regime, the role of CSG in the changed circumstances caused by the pandemic, which has not only disrupted the supply chains, but has also changed how highly globalized and interconnected trade is now being viewed by countries. So we have with us participants, speakers from across the world who will be providing their inputs on various aspects of CISG and the role it's played in the last 40 years, along with the expected role in the near future. This symposium shall be conducted over a period of 2 days, with multiple sessions spanning today and tomorrow. The theme of the sessions today is CISG at 40, Role of UNCITRAL Instruments in Progressive Development of Cross-Border Legal Regime and Trade. And we'll be having our 4 separate sessions on different topics under this theme. It gives me immense pleasure now to call upon Vice Chancellor Shri Krishna Deva Rao to open the session and issue his welcoming address to all the participants.
Good morning. I extend a very warm welcome to Mr. Anup Mendiratha, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India. Mr. P. Harish, Additional Secretary, Ministry of External Affairs, Government of India, will be joining very soon. Atitha, Head UNCITRAL Regional Center for Asia Pacific. Luca, Legal Officer, UNCITRAL. My colleague, Risham Garg, friends. Today, legal education has become increasingly interdisciplinary, interprofessional, and international. The 5-year integrated law program offered by the national law universities in India stands testimony to this interdisciplinarity in the curriculum, pedagogy, and teaching methods. Further, the interdisciplinary learning has been one of the key important features of the recent Government of India's New Education Policy 2020. Interprofessionalism, we have seen, which is again visible with the globalization where several professions are coming together, learning from each other. Particularly, we could see this interprofessionalism reflected in attempt to explore linkages of legal profession with other professions, particularly the finance, accountancy, information technology, entertainment, and health, etc. Of course, we all live in a global era marked by global markets, global connections, global governance, and global rights. This makes legal education more international. So I am glad that our university, National Law University Delhi, is hosting this symposium on transnational commercial law, which has assumed greater significance in the modern times due to the international business transactions. Added to these are the new emerging contemporary areas such as insolvency and entrepreneurship, which promotes trade and development. Insolvency and entrepreneurship are the new innovations in the legal education and legal practice. Entrepreneurship is the art of transforming an innovative idea into a sustainable enterprise that generates value. It can involve intention, creativity, and management, starting a small business or becoming self-employed. The success of the international instruments on transnational law has brought all of us together at this symposium organized by our Center for Transnational Commercial Law. For the past 40 years, contracts for the international sale of goods have become a source of inspiration for regional and national law reforms. Moreover, the influence of the UN Convention on contract for international sale of goods has not been limited only to the contract of sale of goods, but has also extended to aspects of general contract law. As of 2020, the convention has been ratified by 94 countries that represent over 2/3 of the global economy. The UN Convention on Contracts of International Sale of Goods represents a remarkable achievement in the harmonization of International Convention of Sale of Goods. We all know it's a multilateral treaty that establishes a uniform legal regime for contracts for the cross-border sale of goods. It provides a valuable framework for international trade with an efficient, modern, and comprehensive policy to support the commercial activities. It's indeed a great pleasure and honor to welcome you all to this conference celebrating the 40th anniversary of the CISG in the presence of the most outstanding experts and of persons driven by the same interest and aspiration. I appreciate my colleagues for organizing this conference and look forward to more enriching sessions planned for the next 2 days. On behalf of the National Law University, Delhi, I express my sincere gratitude to all the distinguished guests, delegates, sponsors, and students who have taken efforts to be present and make this inaugural function a successful event. Thank you all.
Thank you, Professor Rao. It was indeed very enriching to hear your thoughts on the topic. I would now like to play a short video containing the opening remarks of Ms. Athita Commander, who is the head of UNCITRAL Regional Center for Asia and Pacific. She was set to join us today morning. However, due to some unforeseeable circumstances, she is not available. But she has sent her opening remarks to us, and I will just be playing that recording here.
Honorable Justices and law students of the Center for Transnational Commercial Law, University, Delhi. National Law University, Delhi. Greetings from the United Nations Commission. My name is Athita Commander, head of UNCITRAL RCAP. It is my great pleasure to deliver these remarks opening the 2020 NLUD UNCITRAL Asia Pacific Day Symposium. It is my great pleasure to deliver these remarks opening the 2020 NLUD UNCITRAL Asia Pacific.
I'm so sorry for the disturbance. I think it's been played twice. That's why it's leading to these issues. I'll just play it again, and I'll request all other coordinators to not try to play it so that there's no disturbance.
Honorable Justices, distinguished speakers, esteemed faculty and law students of the Center for Transnational Commercial Law, National Law University, Delhi. Greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific in Incheon, Republic of Korea. My name is Athita Commander, head of UNCITRAL RCAP. It is my great pleasure to deliver these remarks opening the 2020 NLUD UNCITRAL Asia Pacific Day Symposium, which commemorates the 40th anniversary of the CISG, discusses UNCITRAL work in mediation and insolvency, and precedes the 4th edition of the International Insolvency and Bankruptcy Moot Competition. Many thanks to our longstanding AP Day partner, the Center for Transnational Commercial Law, NLUG, for their continued support and excellent organization, especially Dr. Risham Garg and the organizing team. RCAP's thanks go also to the Insolvency and Bankruptcy Board of India, Insol India, the International Finance Corporation, IFC World Bank, International Law Institute, Washington, D.C., and the Center for Business and Insolvency Law, Nottingham Law School of the Nottingham Trent University. A brief introduction on UNCITRAL and RCAP before we begin. The United Nations Commission on International Trade Law is the core legal body of the United Nations in the field of international trade and commercial law. Its mandate is to promote the progressive harmonization and modernization of international trade law to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. UNCITRAL texts are negotiated with the involvement of a variety of states representing different legal traditions and levels of economic development. This helps ensure UNCITRAL texts are widely acceptable as offering solutions appropriate to diverse jurisdictions. RCAP is UNCITRAL's only regional center. We opened our doors in 2012 with the support of the South Korean government to carry out UNCITRAL's work in approximately 60 jurisdictions in the Asia-Pacific region. RCAP founded UNCITRAL Asia Pacific Day, an annual flagship series of academic events, to celebrate the United Nations resolution establishing UNCITRAL in December 1966, and to raise awareness of UNCITRAL to law students, our next generation of legal thinkers. This year, despite the pandemic, a groundbreaking total of approximately 25 institutions of higher learning across 10 Asia-Pacific jurisdictions have joined, enabling UNCITRAL RCAP to engage with a collective audience of over 5,000 to discuss how legal harmonization bridges disparities in national legal systems and facilitates cross-border commerce. NLUD's AP Day is the last of the 2020 events, and we could not think of a more fitting way to end this year's series than this impressive virtual symposium. The key takeaway from UNCITRAL is harmonization. UNCITRAL legal instruments, whether they be treaties, model laws, or legislative guides, recognize that the legal certainty afforded by harmonization is universally enjoyed and would decrease the level of risk and transactional costs associated with doing business that may be reflected in lower prices for final users and consumers, thus promoting international trade. UNCITRAL instruments, in addition to harmonizing trade, are useful as they cover the lifespan of a transaction, starting with deal-making via the CISG, today's focal instrument. The comprehensive, modern, and balanced restatement of sales law contained in the CISG is compatible with all economic and legal systems. It is therefore used as a model for regional and domestic law. In an increasing number of cases, adoption of the CISG represents an important step towards contract law modernization, to which the domestic enactment of provisions inspired by the CISG follows. The year 2020 marks the 40th anniversary of the adoption of the CISG. It has been adopted by 94 states belonging to all regions, economic and legal systems. In addition, 13 out of the top 15 global exporters and 12 out of the top 15 global importers are CISG contracting states. The CISG applies to over 80% of the global trade in goods. The CISG has been in force in several Asia-Pacific states for at least 10 years, including in China, Australia, New Zealand, South Korea, and Japan. Newer parties include Vietnam, North Korea, and Laos, with the Philippines and Thailand both seriously considering joining this year, as are the special administrative regions of Hong Kong and Macau, China. With the onset of One Belt, One Road, the CISG will only become more prominent in China, the Asia-Pacific region, and beyond. As my colleague Luca Castellani will also highlight in his special address, UNCITRAL looks forward to more participation from the South Asian region, including India. From a legal perspective, adopting the CISG provides several benefits. First, easier contract management. The main purpose of the contract is to lay down the rights and obligations of the parties. When the parties are aware of their rights and obligations, they can better comply with the contract, and in the event of a dispute, may find it easier to reach a settlement. If a foreign national law is chosen, a party may not be aware of its content and may incur significant costs in ascertaining its legal position under that foreign law. This makes contract management more difficult and litigation more likely. The adoption of the CISG can avoid such challenges. Second, a neutral legal regime. It is good practice for a contract for the international sale of goods to include a clause on the law applicable to the contract. Often, the preference of the party with more bargaining power prevails. This preference may result in the sale being governed by a national law with which the weaker party is not familiar. Similarly, the parties may agree on the application of the law of a third state with which both parties are unfamiliar. The CISG is a uniform text that resulted from international negotiations. As such, it is neutral to all national laws. Parties are more likely to accept the CISG than national law, especially when their places of business are in states parties to the CISG. MSMEs may have limited access to legal advice when negotiating a contract. They are also likely to be the weaker party. Therefore, they may benefit especially from the applicability of the CISG. The third benefit is the CISG simplifies inquiries about applicable law. Practice shows that many contracts do not contain a choice of law clause. In the event of a dispute, the court or arbitrator will need to apply choice of law rules to identify the law applicable to the contract. This inquiry is often complex and time-consuming and can lead to the application of different laws depending on the state in which the dispute is brought, thereby reducing legal predictability in international trade. By default, the CISG applies to contracts concluded between parties whose places of business are in different states' parties, thereby obviating the need for an inquiry into the applicable law. The CISG thus eliminates procedural hurdles and promotes legal predictability. Consequently, disputes can be resolved more efficiently and judicial resources spared. Fourthly, the CISG is an indispensable tool for international business transaction specialists. While the CISG does not aim to be the law of choice for all transactions, it is often the law that best accommodates the interests of the parties. In particular, professional advice on the legal framework of a contract for international sale of goods should always take into account the CISG and provide adequate reasons for not applying it. In addition, the usefulness of the CISG in managing global supply chains has been reaffirmed during the discussions on the application of Article 79 to the effects of the COVID-19 pandemic. Indeed, uniform legal treatment across jurisdictions ensures predictability and fair treatment, and promotes long-term engagement and the sustainable creation of value. Moving on from deal-making via the CISG to dispute resolution, another key area of UNCITRAL work which will be discussed today. Like the New York Convention, the Singapore Convention on Mediation strengthens respect for binding commitments, inspires confidence in the rule of law, and ensures fair treatment in the resolution of disputes arising over contractual rights and obligations. The further advantage of the Singapore Convention is that it would not be necessary to transform the settlement agreement into an award for enforcement purposes. As shown by the growing number of signatories, the Singapore Convention on Mediation is acceptable to states with different legal, social, and economic systems. An astonishing 46 countries signed the Singapore Convention during the opening ceremony. On that first day, it opened for signing, making it one of the most successful conventions developed by UNCITRAL thus far in terms of signatures obtained on opening day. Approximately half of the signatories are in the Asia-Pacific region, including India, and 4 of the 6 ratifying states are also from the region, namely Singapore, Fiji, Qatar, and Saudi Arabia. The Singapore Convention entered into force on 12 September 2020, just about 3 months ago, and like the New York Convention, its benefits will only be amplified as the number of state parties increases. In addition to today's discussions on the CISG and the Singapore Convention, tomorrow's focus on UNCITRAL's work in cross-border insolvency is also especially timely. As COVID-19 continues to disrupt global trade, the need for harmonization in all legally enabling areas has become more pressing than ever. By way of background, while the number of cross-border insolvency cases has increased significantly since the 1990s, the adoption of national or international legal regimes equipped to address the issues raised by those cases has not kept pace. The lack of such regimes has often resulted in inadequate and uncoordinated approaches to cross-border insolvency that are not only unpredictable and time-consuming in their application, but also lacking transparency and the necessary tools to address the disparities. It is therefore encouraging that a recent case from the National Company Law Tribunal, NCLT, seemed to read the UNCITRAL model law on cross-border insolvency into India's insolvency code framework, which UNCITRAL hopes anticipates or bolsters legislative efforts in India to adopt the model law. Most of RCAP's UNCITRAL AP Day events this year, including today's event, form part of a series of activities that the UNCITRAL Secretariat is organizing around the world to celebrate the CISG, collectively referred to as the CISG at 40 initiative. The first objective of the CISG at 40 initiative is to further increase states' participation in the CISG. The broader its coverage, the greater its benefits to businesses around the world. An additional objective is to support the broader use of the CISG in legal practice, and to promote the uniform interpretation of the CISG, recognizing its character as a uniform law text and ensuring that it has the intended certainty and legal predictability across all jurisdictions. It is thus worth noting that in addition to its broad adoption, more than 5,000 decisions applying the CISG have been reported. Many of these are available on the Case Law on UNCITRAL Text or the CLOUT database and the Digest of Case Law on the CISG. These tools, which have recently been revamped, are available at no cost on the UNCITRAL website in all the official languages of the United Nations. So these 2 days of discussions and the insolvency moot should be very interesting indeed. And UNCITRAL RCAP is very happy at this opportunity to engage with students, academics, and practitioners of international trade and commercial law in India and the Asia Pacific region. To students in the audience, UNCITRAL in Vienna and UNCITRAL RCAP in Incheon have internship application opportunities twice a year in December and June. RCAP has welcomed interns from all quarters of the world, including India, and would encourage those interested to apply on the United Nations Career website. This month, RCAP has just opened applications for our next batch of interns, so please visit the United Nations Careers webpage if you're interested. On that last note, please accept again the thanks of UNCITRAL RCAP for co-hosting the 2020 UNCITRAL Asia Pacific Day. I wish you a very successful symposium.
Joining us today morning are with us our guests of honor, Mr. P. Harish, Additional Secretary, Ministry of External Affairs, Government of India, and Mr. Anup Mendirata, Secretary, Department of Legal Affairs of the Ministry of Law and Justice. I would like to call upon Mr. P. Harish now to offer his remarks on the symposium.
Thank you, ma'am. Satita Komender, Head of UNCITRAL Regional Center for the Asia Pacific, Mr. Anup Mendirata, Secretary, Department of Legal Affairs of the Government of India, Professor Sri Krishna Deva Rao, Vice Chancellor of the National Law University of Delhi. Distinguished guests, ladies and gentlemen. For me, it's indeed a pleasure to be here today to deliver this address at the inaugural session of the Symposium, commemorating 40 years of the Convention on International Sale of Goods, though India is not a signatory to this particular convention. But building on its ancient civilizational commitment to deep humanism, universal peace and fraternity, most aptly symbolized by Vasudhaiva Kutumbakam, or the whole world is one family, India has been a founding member of several pioneering multilateral institutions, ranging from the League of Nations, United Nations, and UNCITRAL was established in 1966 with the recognition that international trade cooperation among states is an important factor in the promotion of friendly relations and consequently in the maintenance of peace and security. Through its model laws, conventions, legislative guides, and robust debates and working groups, UNCITRAL has provided a valuable platform for countries to compare, examine, debate, and adopt principles of international law that are appropriate for their national circumstances. India has active membership and participation in diverse multilateral and regional fora, from the Arctic Council, the Pacific Alliance, the BRICS, BIMSTEC, G20 to the UN Security Council, where India is a member now and also legitimately seeks permanent membership. India is part of a commitment to the purposes and principles of the United Nations, and the evolution of its specialized programs and agencies has been at the forefront of promoting international rule of law and harmonization of international trade law. It's a glowing testament to India's commitment to the rule of law that India is only one of the 8 countries that has been a member of UNCITRAL since inception. We recognize that the impact of UNCITRAL has been far beyond merely facilitation of international trade. Its exemplary work over the years has provided significant thought leadership that has inspired transformation of several domestic legal regimes to enable both domestic and international commerce and trade. India's commitment to upholding the rule of international law goes beyond meeting the text of the law to upholding the spirit of the law. Thus, India does not believe in hollowing out the spirit of international trade law through extra-legal, non-tariff and other measures. Ladies and gentlemen, I take this opportunity to commend the work of UNCITRAL to have created conventions and model laws that are acceptable worldwide. UNCITRAL has created practical legal and legislative guides and has updated the database of uniform commercial law and judicial decisions. Its conventions and its model legal texts have formed the basis of new enactments in India and amendments to our legislation. I'm glad that the Silver Jubilee celebrations of UNCITRAL in the Asia-Pacific region was hosted by India. And I would like to take this opportunity to thank the UNCITRAL Secretariat for engaging with India on discussions related to the ongoing work of UNCITRAL and for the proposed conference that was to be held in New Delhi last year, involving senior judicial and legal personalities, along with the Ministry of External Affairs and the UNCITRAL National Coordination Committee for India, which unfortunately could not take place due to the ongoing pandemic and restrictions. Despite these unprecedented times, the virtual world has helped the UNCITRAL Regional Center for Asia and the Pacific and the UNCCI to conduct a series of webinars on India-specific topics, which were not only extremely relevant, but also intellectually stimulating. At the 53rd session of the Commission last year, held virtually, the Commission, through various panel discussions, considered the role that UNCITRAL text could play in assisting states with their COVID-19 economic response, which truly reflects the adaptability of the text with changing times. During these times, I shared the goal of other UNCITRAL member states that there is a need to move ahead with the work of UNCITRAL using alternative methods of work, including remote means of communication, to ensure progress in the work and objectives of UNCITRAL. The key highlights of UNCITRAL over the last year include, of course, the entry into force of the Singapore Convention that we just heard Ms. Athira speak about, the progress made by Working Group 1 on the legislative guide for an UNCITRAL limited liability organization aimed at reducing the legal obstacles faced by MSMEs is particularly important to developing economies like us. The continued consideration by UNCITRAL on improving the efficiency and quality of arbitral proceedings that pave the way for reduction in costs and duration of the proceedings should benefit all parties. Ladies and gentlemen, India is a signatory to several investment treaties, and in recognition of the changing investment landscape, our investment treaty regime strives to align the objective of investment with sustainable development and inclusive growth. While welcoming and protecting foreign investment, the Model Bilateral Investment Treaty reaffirms the right of parties to regulate investments in their territory in accordance with their law and policy objectives. It's heartening to note that UNCITRAL is taking the lead in furthering debate and harmonization in the area of investor-state dispute settlement. We should recognize that investment treaties are designed to carefully balance the commercial interests of investors and the sovereign rights and policy space of states. In recent times, this delicate balance and harmony has been disturbed, and there have been increasing instances of abuse of process. It's vitally important that all stakeholders address this issue to help restore the credibility of the ISDS system. In this regard, the progress of the work of UNCITRAL Working Group 3 on Investor-State Dispute Settlement Reform is to be highly commended. The two possible reform solutions being discussed include reforming the current system in a step-by-step process and a structural reform which includes the creation of a World Investment Court with an appellate body. State parties have agreed to pursue both work streams simultaneously in order to give ample opportunity and accommodate all the parties and have consensus on the way forward. Undoubtedly, one of the most successful conventions ever adopted by the UN is the UN Convention on the Recognition and Enforcement of Arbitral Awards, the New York Convention, and it deserves special attention. The accessions by Palau and Tonga to the New York Convention has taken this number to 164 state parties. India was one of the initial signatories to the convention, and the development of Indian jurisprudence in this field of law is reflected in the Cloud Digest. The cloud system, indeed, is an important tool to collect information on the use and implementation of unsatral texts. This contributes to the delivery of continued and sustained capacity building efforts, including in India. We appreciate deeply the work of the national correspondents to cloud, who play an important role in providing information on the use and implementation of these unsatral texts. This information is useful for identifying needs for future legislative work. I take this opportunity to draw your attention and appreciate the work of the nominated national correspondents to cloud from India. And I'm glad that Indian cases have been published in the latest Cloud Digest. I hope that your deliberations will explore further means to foster a healthy and sustainable culture to international rule of law among all stakeholders. Respect for rule of law should be universal. It should not be opportunistic. I believe that deliberations in this two-day conference on important topics ranging from commercial arbitration, ISDS, insolvency, etc., will catalyze and rejuvenate Antitrust's efforts towards harmonization of critical international trade and commercial legislation. The objectives of Antitrust stand integrated with the realms of different legal regimes in the world. The harmonious nature of deliberation and consolidation into principle represents one of the surest protections of international peace and security. For the past half a century, UNCITRAL has been recognized as a central arm of the UN system in the field of international trade and commercial law. This conference, I hope, is an occasion for us to truly understand the impact of UNCITRAL, and I wish you all success in your deliberations. Thank you.
Thank you so much, sir. It was indeed very insightful to have your comments directly from the government's perspective on how we are viewing CISD and the role India will be playing. Now, I'll take this opportunity to call upon Mr. Anup Kumar Mendirata to give us his valuable insights on the topic. So, may I request you to please unmute your audio? Thank you, sir.
Thank you. Professor Krishnadev Rao, Vice Chancellor, National Law University, Delhi. Atheta Komedar, Head UNCITRAL. Shri P. Harish, Additional Secretary, Ministry of External Affairs. Luca Castellani, Legal Officer. Professor G.S. Bajpai, other distinguished professors, participants, ladies and gentlemen. It is my immense pleasure and privilege being with you on the occasion of the inaugural session of the UNCITRAL Symposium and feel it as a great opportunity to share my views. Globalization refers to the process of integration and convergence of economic, financial, cultural, and political systems across the world by adopting a holistic approach. From an economic or commercial perspective, it is economic integration and interdependence of national economies across the world through a rapid rise in the cross-border movement of goods, services, technology, and capital. The rapid growth of integration and interdependence of economies may be attributed to the interconnectedness of the various dimensions of economic globalization, such as globalization of production markets, competition, technology, corporations, and industries. Further, international business encompasses all those business activities that involve cross-border transactions of goods, services, and resources between two or more nations. It is seen that countries rarely follow the trade structure for export and imports. Besides, nations have marked differences in their vulnerabilities to upheavals in the exogenous factors. In simple terms, international business implies the conduct of business activities beyond the national boundaries. It is much wider term comprising of all the commercial transactions taking place between two countries. It includes international trade, international marketing, international investments, international management. During the COVID times, we have seen several challenges posed by the COVID-19 pandemic. COVID-19 may create stress on external commercial borrowings and guarantees issued for overseas borrowings by the corporates. The consequences will not only be bitter for the corporates, but also for the larger fraternity of creditors in India in case a cross-border insolvency framework is not implemented at the earliest. The ongoing pandemic has posed several challenging questions regarding robustness of insolvency laws, dealing with cross-border insolvencies, and has necessitated a comprehensive response. The choice of framework, however, depends on the country's level of integration with global economy, maturity of insolvency system currently in place, maturity of legal systems in general, amongst other things. The major international and multilateral institutions have come up under the aegis of the UN system, such as the World Trade Organization, WTO, the World Bank, International Monetary Fund, United Nations Conference on Trade and Development, and International Trade Center. The WTO provides a rule-based multilateral framework for international trade and deals with a variety of issues such as tariffs, non-tariff barriers, market access, intellectual property rights, subsidies, countervailing measures, rules, policy framework, dumping, etc. International trade and investment are correlated, and the last decade has seen a dramatic increase in foreign direct investment defined as ownership and control of a business or a part of business in another country. In recent years, many developing countries in pursuit of liberalizing and globalizing their economies have moved to dismantle many explicit barriers and disincentives, such as limits on the percentage of an enterprise that can be foreign-owned and on repatriation of profits. Ownership by foreigners has become an increasing concern in some industrialized countries, especially in Western world, which traditionally complained of non-liberal attitudes elsewhere towards the foreign investment. It may also be observed that the Havana Charter for International Trade Organization 1947 provided in a very scant manner provision on the encouragement of the international flow of capital for the productive investment. It was further recognized that the international flow of capital will be stimulated to the extent that members afford nationals of other countries opportunities for investment and security for existing and future investments. Prior to the WTO Agreement on Trade-Related Investment Measures, TRIPS, there was no multilateral agreement comprehensively dealing with investment issues. However, trading parties commonly enter into the so-called bilateral investment treaties, in which core issues of the conditions of foreign investment, the standards of compensation in cases of expropriation, and investor-related remedies are often incorporated in investment state arbitration mechanisms. Since 1959 and by the end of the year 2001, more than 1,100 developing countries have entered into these agreements. The essential normative order for investment in BITS is to promote greater economic cooperation between the parties and to encourage the flow of private capital and create conditions conducive to such flow. Investment was a major issue during the Uruguay round negotiations. The negotiations in the context of GATS, TRIPS, government procurement and subsidies, as well as MAI and discussions at the WTO Working Group on Trade and Investment have demonstrated that many countries continue to have concerns with providing right of establishment to foreign investment and consider it important to maintain flexibility in their economic and development policies. The United Nations Convention on Contracts for the International Sale of Goods, CISG, is a multilateral treaty that establishes a uniform legal regime for contracts for the cross-border sale of goods. Such sales contracts operate as the backbone of the international trade, and uniform rules for sales contracts provide traders with an efficient, modern, and comprehensive legal framework to support their commercial activities. Its uniform rules specifically designed to meet the needs of cross-border commerce, increase certainty in commercial transactions, and decrease their cost. The CIG thus supports sustainable economic development in general, and because risks and costs are disproportionately felt by small and medium-sized enterprises, is of particular benefit in promoting cross-border commercial activities on their part. The United Nations Commission on International Trade Law, UNCITRAL, established by the United Nations Assembly by resolution of 17 December 1966, plays an important role in developing that framework in pursuance of its mandate to further the progressive harmonization and modernization of the law of international trade by preparing and promoting the use and adoption of legislative and non-legislative instruments in a number of key areas of commercial law. UNCITRAL is a formulating modern, fair, and harmonized rules on commercialized transactions. These include conventions, model laws and rules which are acceptable worldwide, legal and legislative guides, and recommendations of great practical value, updated information on case law and enactments of uniform commercial law, technical assistance in law reform projects, regional and national seminars on uniform commercial law. The UNCITRAL arbitration rules also provide a comprehensive set of procedural rules upon which parties may agree for the conduct of arbitral proceedings arising out of the commercial relationship and are widely used in ad hoc arbitrations as well as administered arbitrations. The rules cover all aspects of the arbitral process, providing a model arbitration clause, setting out procedural rules regarding the appointment of arbitrators and conduct of arbitral proceedings, and establishing rules in relation to the form, effect, and interpretation of the award. So far as the Indian perspective is concerned, the Indian BIT-BIPA was initiated as a part of the economic reforms program started in 1999-1991 with a view to increase the integration of Indian economy with the global economy by fostering inward and outward investment flows. The government of India so far has signed several BIPAs with more than 83 countries after having negotiations on the basis of negotiating text approved by the Steering Committee on Economic Reforms. The general requirements in the Indian BIT-BIPA are to provide that neither party shall mandate as condition for the establishment, acquisition, or operation of a covered investment any of the following performance requirements, that is the non-discriminatory treatment, fair and equitable treatment, full security and protection, thirdly the expropriation clause, the compensation, and the dispute settlement. Of late, Government of India has received some notices of dispute and arbitration from foreign investors invoking provisions of various BIPAs not necessarily signed with the resident country of such an investor. Further, Government of India also received an adverse arbitration award in 2011 in the case filed by Messrs. White Industries Australia Limited under the BIPA with Australia. In my opinion, the said decision should have been challenged. The dispute awards or notices and other developments in the area of BIPA have led to review of all such cases filed or pending. Apart from the concerns of violation of non-discriminatory treatment, FET investment disputes also raises several concerns like cross-border insolvency, etc. However, an important concern in some of the dispute relates to the vitiation of agreement itself due to fraud and corruption, which needs to be suitably looked into since it affects the very foundation of the agreement. The Arbitration and Conciliation Act 1996 contains a coherent and model framework. It envisages only one award under one set of rules. It does not contemplate multi-layer awards governed by different set of rules. It has introduced several changes, of which three are worth taking note of. Firstly, the fair resolution of a dispute by an impartial tribunal without any unnecessary delay or expenses. Secondly, the party autonomy is paramount, subject only to such safeguards as are necessary in public interest. Thirdly, the arbitral tribunal is enjoined with the duty to act fairly and impartially. Several new initiatives have also been taken to facilitate cross-border trade and investment. The amendments have been carried in the Specific Relief Act 1963, amendments in the Arbitration and Conciliation Act 1996, Wide Amendment Act 2019, amendment in Commercial Codes Act 2015, the New Delhi International Arbitration Center Act 2019 to make India as an international hub of arbitration. The Arbitration and Conciliation Amendment Ordinance 2020 is the latest in the series, wherein Schedule 8 has been deleted, which has led to some speculation amongst the foreign arbitrators in respect of the arbitrate accreditation to be carried. Any rules, any regulations in this regard would be subsequently considered by the Arbitration Council of India, which is contemplated under the Arbitration and Conciliation Act. Also, the amendments have been carried in IBC 2016 to address the situation developed due to pandemic. Concludingly, I would say that although in the last 4 decades, national and international legal policies and rules concerning trade and investments have repeatedly changed, the investment and its varieties have also undergone substantial transformation in its magnitude and content. And the national laws and policies, the trend towards liberalization and increased protection have gathered strength, and the controls and restrictions have been relaxed. Non-discriminatory treatment after admission of investment, either by way of FDI or portfolio, is becoming the rule rather than an exception. I would say that law, being a living organ, has to grow in order to satisfy the needs of the fast-changing society and to keep abreast with the economic developments taking place in the country. As new situations arise, the law has to evolve in order to meet the challenge of such new situations and cannot remain static. We have to evolve new principles and lay down new norms which would adequately deal with the new problems which arise in a highly industrialized economy. I hope and wish this symposium will highlight the pros and cons of the subject and will stimulate innovative ideas to boost cross-border trade. With these words, I conclude and once again thank the organizers for giving me this opportunity. Jai Hind. Thank you.
Many thanks sir, for your very valuable comments on the topic and for charting out India's legal journey with the INCITRAL. It was very enriching for the audience, I'm sure. Joining us today this morning was also Ms. Luca Castellani, who is the legal officer at the UNCITRAL. However, due to some unavoidable circumstances, she could not join us, but has also sent us her remarks. So I will request Mr. Arif to please play Ms. Luca's remarks now.
Dear colleague and friends, a very good morning from the UNCITRAL Secretariat in Vienna, Austria. It is an honor to be here today and to have the ability to talk at the Symposium on Transnational Commercial Law, Insolvency, Restructuring, Entrepreneurship, Promoting Trade and Development post the pandemic. My name is Luca Castellani. I am a legal officer in the UNCITRAL Secretariat. I would like to thank very much the organizers of this important event, the Center for Transnational Commercial Law, the National Law University, Delhi, internal quality assurance cell, and then all the other supporters, starting with my dear colleagues at the Ancestral Regional Center for Asia and the Pacific, the Insolvency and Bankruptcy Board of India, Insol India, the International Law Institute, the Ancestral National Coordination Committee of India, Campbell University, Wiggin School of Law, Nottingham Law School at Nottingham Trent University. Thank you very much for organizing this timely event. I would like to share with you some considerations about the CSG, as today the main topic of discussion is exactly the United Nations Convention on Contracts for the International Sale of Goods, or CISG. Please allow me to share some slides. As you know, the CSG has already been adopted by 94 states. These 94 states represent over 80% of global trade when put together. We know the CSG is widely used. There are more than 5,000 judicial and decisions and arbitral awards that apply the CSG reported, where these are available, often available online at no cost. We know many more are not reported. This is especially true for arbitral awards, where maybe confidentiality prevents the reporting. 5,000 is a big number, so if you want to have an easier orientation, you can look, for instance, at the Ancestral Digest of Case Law, also available for free on the Ancestral website. It's a very clear and agile guide, and yet, because there are so many cases, it's more than 500 pages long. But it gives you really good guidance on CSG interpretation and application. The CSG is a significant intellectual and network of different texts. The Limitation Convention, that is to say, the Convention on the Limitation Period in Contracts for International Sale of Goods, which was the forerunner of the CSG, and it's functionally, it complements the CSG, really important field, very complex. The UNIDROIT Principles of International Commercial Contracts, of course, they have a different nature, but let's not forget that UNIDROIT gave a very significant contribution to drafting the CSG, and then took the CSG as the basis for further work, expanding the scope and drafting these very important principles. And most recently, of course, the Hague Principles on Choice of Law in International Commercial Contracts, also really significant. They complement the CSG, it's mutually reinforcing, in order to give traders the best options to allocate risks, distribute obligations and rights, and carry out cross-border trade successfully. Please allow me to be proud in sharing that with now past year 2020, we have finalized the legal guide to uniform instruments in the area of international commercial contracts with a focus on sales. This is called the tripartite guide because it was co-drafted by the secretariats of the Hague Conference of Private International Law, of Ancestral and of UNIDROIT. So you have here the top 3 global intergovernmental organizations. what's the purpose of this guide? This guide is not so much to explain each text of these three organizations and also other texts, for instance, regional texts. It's not the purpose to explain their content, their substance, but rather the purpose is to explain how they interact with each other. That's really important because we have more than half a century of work in this field. And sometimes it is not possible, even for the specialists, to understand how all of this comes together. But it does come together very nicely. So this was actually started from the celebrations for the 35th anniversary of the CSG. There was a proposal to conduct new work in this field, maybe a new convention, maybe also important suggestion to prepare a model law. But instead, UNCITRAL said, no, let's first look at what is already there, consolidate, so that both states and private parties can properly understand how all of these texts come together. As I said, we finalized, and actually we are launching the English language version, in the final form as an ebook in these days. An advanced draft is available of the UNCITRAL website in the other 5 official languages of the United Nations. So please follow our press releases and follow us on LinkedIn and Facebook, and you make sure you will not miss the announcements. You'll be able to download it and read it and take advantage of this extremely useful tool. The event today is meant to celebrate the 40th anniversary of the adoption of the CSG. That was in the year 2020. Of course, because of the pandemic, we are extending it. And this event of today is part of those celebrations. What are the goals? We want to promote broader adoption by states, review of existing declarations, and also increase the use of the CSG by legal practitioners and by business. Please do visit the dedicated CSG at 40 webpage on the UNCITRAL website, which is uncitral.un.org. You will find news, you will find information about events, additional resources, but in particular, many of these events are recorded and they are available online. So you can really learn a lot by looking at what has been made available on that webpage. The main substantive topic of this brief introductory speech today has to do with the CSG and developing countries, and of course with the CSG and India. In my opinion, the CSG is truly beneficial, especially beneficial to the entrepreneurs established in developing countries. It actually more so when these are small and medium-sized enterprises. But unfortunately, we don't see the same level of engagement in developing countries as we see in developed countries. And so the practical outcome is that we have proportionally more developed countries than developing countries. And we have, for instance, proportionally more countries in the Northern Hemisphere than in the Southern Hemisphere. And of course, we have to do something to bring back a balance here. Why do I say the CSG is really beneficial to business in developing countries? Well, you know, one of the important effects of the CSG, of the adoption and the application of the CSG, is to simplify the choice of law and the identification of the applicable law. In cross-border contracts, usually there is a clause that identifies what's the applicable law. If there is a discussion, often the party that has more bargaining power prevails and may indicate its own law. But typically, that party is not in the developing country, it is in the developed country. Another possible outcome is that the law of a third country is chosen. But in that case, both parties will not be really familiar with the applicable law. That creates problems in contract management. That creates problems especially in preventing disputes. Because to me, prevention of disputes is even much more important than resolution of disputes. It's more efficient to prevent a dispute and to continue the business relationship. But of course, in other cases, especially when access to qualified legal counsel is not easily available, there could be a contract and no choice of law. And then we have to use private international law rules to identify which law is available. Now, this creates issues. First of all, because while we perform the contract, we're not so sure which rules will apply. And so we can perform according to the contract. But if there is a gap in the contract, we are not so sure how to fill that gap. And secondly, there is also the possibility of forum shopping, because private international law rules are not uniform. So depending on the jurisdiction, there could be a different outcome in the applicable law. But if we apply the CSG, of course, we have the advantage that all the parties have the same access to the law and they know its provisions. And also, it may equally be the law in the developing and in the developed countries, so we can level the difference in bargaining power. In practical terms, this makes contract management easier and more transparent, and this, of course, reflects also to supply chain management. If contract management is more efficient, we reduce transaction costs, including the transactions costs that are related to the need of finding out the content of the applicable law once the applicable law is identified. Now, of course, the goal of this symposium today is also to look at the recovery after the pandemic. And it's clear that the pandemic was an exceptional event, whether it is qualified as a force majeure event or a hardship event, it depends very much on the applicable law. But how fortunate it would be to be able to apply the same law across all the jurisdictions touched by the supply chain, so that we have the same way of dealing with the effects of the pandemic across the supply chain. Of course, the CSG has a provision on this issue, on the exemption from liability for non-performance. And then if the parties want so, they can complete that provision by incorporating the relevant parts of the UNIDROIT principles, which is even more detailed. And there is even a uniform clause, very recently revised by the International Chamber of Commerce. So one has a full set, and it's incredibly clear what the parties agreed upon and how they intend to allocate the risk. And so there is no uncertainty, there is no economic loss because of lack of clarity. Last but not least, as you know, the CSG may be opted out, which is absolutely fine. But it has to reflect actual needs of the parties. But I always say, please do opt out of the CSG as long as you are sure this is the best interest for you and your client. What is really important here is that in many developing countries and in some legal traditions, the notions of freedom of contract and party autonomy are not so well established like in others. But the CSG itself gives the possibility of opting out. So in every country where the CSG has been adopted, it is possible to opt out and it is possible to choose another law. Now, I'm not going to tell you how the Indian legal system operates. I am the least qualified of all the people in this symposium. I just want to draw your attention to the fact that it is true that the CSG has different levels of acceptance. Even across the Asia and the Pacific, for instance, Central Asia is quite popular. In East Asia, Northeast Asia, it's very popular. Southeast Asia and the Pacific now, there's more jurisdictions, but it was not like that for some time. But why South Asia still has no country that is a party to the CSG? I don't think there is a real reason. We look at India, we know the Sale of Goods Act of 1930 is still based on the English Sale of Goods Act of 1893. It's a wonderful piece of legislation, but of course, it was not designed for long-arm transactions. The Indian Law Commission already proposed to reform the Sale of Goods Act in 1958. Now, India was active in drafting the CSG, and there was expectation of early accession, also because of India's commitment to position of developing countries, politically, economically. But somehow the momentum was lost. I had the pleasure to visit your beautiful country some 10 years ago. There was a discussion and most people were favorable to adoption of the CSG. Some expressed some concerns, reservations about the fact that the CSG uses undefined terms. And it does so exactly because it has to maintain flexibility. Cross-border trade may face so many different circumstances in terms of infrastructure, in terms of sophistication of the parties, in terms of goods traded, for instance, commodities or manufactured goods. But we have the 5,000 plus decisions that give us a lot of guidance on the interpretation. So I don't think that the fact that the term is not strictly defined in the treaty itself is an issue, because we have a lot of precedents helping us to understand how it should be implemented. Of course, India's adoption would send a really strong signal of its commitment to international trade law. May I say more than that? Out of the 20 largest economies in the world, only 4 are not parties to the CSG, and India is one of the largest missing ones, if not the largest. Should India adopt the CSG, it would promote cross-border trade by increasing legal predictability and reducing transaction costs. And it would also start important process of modernization of this key area of contract law. This would be important. Of course, it would have positive effects also on the providers of legal services, because that would mean encouraging the lawyers and legal counsels to become familiar with the CSG and also to engage in a reflection on modern sales law. My experience, and bearing in mind today's audience, academia and students may really play a very important role in sensitizing the government. And of course, I have to add the National Coordination Committee in both countries like India that have it. But for instance, in Brazil and in Vietnam, it was academics and students who started the discussion and started to put forward a proposal that was successful. I really hope this new year, 2021, will bring us a lot of wonderful things. And one of them, hopefully, will be that India starts considering the adoption of the CSG. I thank you very much for your attention. And I wish you all success with this important symposium and with your other professional endeavors. Thank you very much.
Thank you. Hoping everyone found it very useful. I will now call upon Professor Risham Garg, Director of CTCL and Associate Professor of Law at NLU Delhi, to say a few words about the symposium. This symposium was his brainchild 3 years back, and without his relentless efforts for the last 3 years, including this year, the symposium would not have been possible. So, Professor Garg, may I please request you to share your experience and say a few words about the symposium?
Thank you. Thank you, Ria. Actually, my comments should have been delivered at the starting about the symposium, and this is not the appropriate place for me to say anything. But regardless, I will say two lines upon the symposium. Yes, I won't say that this is a brainchild, but yes, it's an effort, and I appreciate the encouragement and support of the university, and certainly some eminent professors of transnational commercial law who have guided me into this field. So, notably, Professor Herbert Kronk and Professor Stefan Fogenauer, who will be speaking later on in another session. What is transnational commercial law? So we also know that there is something called as transnational law, which was made famous by Professor Philip Jessup. But we can basically distinguish between transnational law and transnational commercial law as like between a public law and a private law. And this concept may be kept distinct from notions such as the international business law or international economic law. Now, transnational commercial law basically consists of that set of rules from whatever source which governs international commercial transactions and is common to a number of legal systems. And such commonality is derived from international instruments of various kinds, such as conventions and model laws, and from codification of international trade usage adopted by contract. Now, why did we plan this particular symposium at this time? Everybody we know in the last nearly a year, the global economy has been ravaged by a pandemic. Supply chains have been in a standstill, and there is no doubt that we require cross-border trade. So cross-border trade is the great enabler for growth and development. To ensure that, we need a robust legal regime. And our bit is that, the private law in the form of transnational commercial law, to what extent it can aid the robust legal regime to promote that cross-border trade and certainly try to establish India as a leader in global supply chains. So it's interesting, in my discussion and conversations with our eminent partners, the Nottingham Trent University, Professor Rebecca Perry, the Washington in the Washington, the Georgetown University's Law Center, the Campbell Law School. So we have been discussing, and we found out, yes, let's try to stitch together such a conference where we can have certain, not all, but certain crucial areas which are of burning global importance. And that is how we stitched together this conference. And I'm sure after listening to Athita and Luca that our plans was in the correct direction. So it was this conference, this symposium was again like a synthesis. It's again, it was planned, but most of the things happened by chance. And I do hope that we are lucky and we are able to take this forward. And I do assure all the participants for great 2 days ahead.
Many thanks, sir. So with this, we have come to the end of our inaugural session. I would call upon Professor G.S. Bajpai, Registrar of New Delhi, to offer his vote of thanks to close the ceremony. So may I please request you to unmute yourself? Thank you, sir.
So good morning all, and I take this opportunity to thank all who have assisted this entire conference, which is focused on transnational commercial laws, insolvency, restructuring, entrepreneurship, promoting trade and development post the pandemic, organized between 6th and 7th January. And I'm sure this symposium must have provided a wonderful platform to enable the professionals from different parts of the world and from different spheres of work to engage on various issues relating to transnational commercial laws, insolvency law, restructuring, entrepreneurship, trade and development post-pandemic. Transnational commercial law has generated great significance, especially in modern times of international business and commerce. Therefore, the transnational commercial law has come to be recognized as a predefined set of rules that govern international trade and commercial transactions. Several instruments such as conventions, model laws, along with the international trade uses have come to make up this realm, transnational commercial laws. For instance, we may refer to the model arbitration rules by the United Nations Commission on International Trade Law, the UNIDROIT principles of international commercial contracts, the United Nations Convention on Contracts for the international sale of goods, and so on. For this reason, I would like to express my gratitude to all attendees, students, participants, and professionals who have taken part in this virtual conference. I would like to congratulate the Center of Transnational Commercial Laws at National Law University, Delhi, for successfully organizing this conference, and also extend my gratitude for all the support from the Insolvency and Bankruptcy Board of India, the Ancestral Regional Center for Asia and the Pacific, the International Law Institute, Washington, D.C., the Center on Transnational Business and the Law, Georgetown University, the Norman Adrian Wiggins School of Law, Campbell University, US, the Nottingham Law School, Nottingham Trent University, UK, INSOL India, UNCC India. I hope that this conference will be an eye-opener to issues of transnational commercial laws, and all participants have opportunity of learning from top professionals in the field. On behalf of the National Law University family, I express my sincere gratitude to all the distinguished guests, delegates, sponsors, and students who have taken efforts to be present for this function. For even today's closing function, I acknowledge the kind presence of our guest, Mr. Luca Castellini, Legal Officer, Ancestral, Mr. P. Harish, the Additional Secretary, Ministry of External Affairs, and of course, Mr. Anup Mehndiratta, Secretary, Department of Legal Affairs, Ministry of Law and Justice, and above all, the support and the patronage of our Vice Chancellor, Professor Shri Krishna Dev Rao, for promoting and patronizing this event is something which motivates the organizing of such event. Needless to say that my colleague, Dr. Rishamgar, who is also the director of the Center for Transnational Commercial Law, under his able guidance and coordination, this 2 days conference could be successfully organized. I thank one and all for supporting this event. Thank you and all the best. Jai Hind.
Thank you so much, sir. I thank all the dignitaries present here and all the participants for joining us this morning for the inaugural session. The sessions will be starting soon. I have shared the brochure in the chat box. The schedule is mentioned in the brochure. You can use the same link to join for the sessions according to the schedule, and we'll be redirected to the sessions accordingly. Thank you once again for joining us today.